Good morning, I'm Gary DeWaal, and this is Bridging the Week for March 7th to 11th, and today is March 14th, 2016. Last week, a federal court in New York permitted a lawsuit to proceed alleging that the United States Attorney and other government officials violated the civil rights of a former hedge fund operator. In addition, both ICE Futures US and CME Group settled a number of disciplinary actions alleging possible spoofing and market disruption, liquidating positions in a disorderly fashion, and trading based on non-public customer information. Finally, ICE Futures US proposed amending one of its rules to permit the possible disaggregation of certain positions among affiliated persons for position limits calculation purposes to parallel a rule proposed by the Commodity Futures Trading Commission but not yet adopted. We have a lot of interesting developments impacting financial services participants this week, the first week after the beginning of daylight savings times in the United States, so let's get started. A federal court in New York City refused to dismiss a lawsuit against Preet Bharara, the United States Attorney for the Southern District of New York, and various FBI agents and employees of the United States Attorney's Office, alleging violations of the civil rights of David Ganek, a former hedge fund operator. Mr. Ganek filed a lawsuit against the defendants in February 2015 after he shut down his hedge fund, Level Global Investors, following a highly publicized raid by FBI agents on Level Global's offices in November 2010. The raid was part of the U.S. Attorney's Office investigation of possible insider trading by financial professionals. In his complaint, Mr. Ganek alleged that an affidavit presented to a magistrate to authorize the raid, quote, contained deliberate misrepresentations that later were exposed by sworn trial testimony of an FBI agent and a government informant, end of quote. However, claimed Mr. Ganek, defendants had no basis for the statement that in fact constituted a fabrication. Saying that Mr. Ganek's complaint contained quote-unquote grave allegations, the Honorable William Pauley III, the judge deciding this matter, ruled mostly against defendants' motion to dismiss and permitted Mr. Ganek's lawsuit, which alleged violations of certain of his constitutional rights, to proceed. ICE Futures US filed and settled charges against James Shrewsbury, claiming that on multiple occasions from November 2014 and March 2015, he may have engaged in trading practices that constituted spoofing and disruptive trading in violation of exchange rules. Specifically, ICE Futures US alleged that during the relevant time, Mr. Shrewsbury engaged in a pattern of activity where he would enter an iceberg order at the best bidder offer. He would then enter a large, fully displayed order on the opposite side of the market that, quote, appeared to create artificial pressure and appeared to be misleading market participants into trading opposite the pre-positioned iceberg order, end of quote, alleged IFUS. IFUS claimed that Mr. Shrewsbury would then cancel his large order within seconds of his iceberg order being executed. To resolve this matter, Mr. Shrewsbury agreed to pay a fine of almost $140,000 US and to disgorge profits of almost $70,000 US. He also agreed to a 10-day suspension from access to all ICE Futures US trading platforms. Separately, Glencore Grain BV agreed to pay a fine of $200,000 US to settle charges by ICE Futures US that on one day it may have violated position limits in July 2014 Cotton No. 2 futures contract. In addition, alleged ICE Futures US, the firm may have caused price movement in the relevant futures contract and a corresponding July-December 2014 futures spread when, in response to requests by the exchange to reduce positions, the firm, quote, waited until the final 20 minutes of trading to execute a high proportion of their transactions on the day prior to first notice day, end of quote. Staff of the Division of Swap Dealer and Intermediary Oversight of the Commodity Futures Trading Commission issued guidance regarding elements of an effective risk management program. Although staff's guidance is expressly limited to the application of its risk management program requirements to Futures Commission merchants that handle customer funds, a similar requirement to maintain risk management programs applies to swap dealers and major swap participants. Although staff indicated that similar guidance might be issued to swap dealers and major swap participants later, this FCM guidance should be considered by swap dealers and major swap participants, by analogy, to evaluate the adequacy of their own risk management programs. CHS Inc. and Hedging LLC, a wholly owned subsidiary of CHS, agreed to pay a fine of $1 million for their failure to accurately report CHS's physical commodity positions from at least January 2000 until May 2013. CHS is an agricultural cooperative not registered with the CFTC in any capacity, while CHS Hedging is registered with the CFTC as a Futures Commission merchant. According to the CFTC, during the relevant time, CHS maintained reportable positions in corn and soybean futures to hedge fixed-price physical corn and soybean positions. As a result, the firm was obligated to file a monthly report of its fixed-price physical positions, known as a Form 204, with the CFTC. During the relevant time, CHS Hedging filed this report on behalf of CHS. However, mistakenly, said the CFTC, CHS Hedging incorrectly included the same fixed position throughout the relevant time period for one of the 3 CHS business units that it was required to aggregate to report CHS's overall positions. ICE Futures US intends to implement a rule change that potentially permits a person from not having to aggregate its positions with a related entity. Under the ICE Futures US amended rule, a person could apply to the exchange for authority not to aggregate its positions with another person where it holds a 10% or greater equity interest if the individuals controlling the trading of the relevant accounts do not have knowledge of each other's trading decisions, the accounts are traded pursuant to separately developed and independent trade strategies, there are written procedures precluding access to information regarding the trades, positions, and strategies of each account, and there is no sharing of information by the person controlling each account's trading decisions. The relief modeled after similar disaggregation proposal of the Commodity Futures Trading Commission made in September 2015 would not apply to ICE Futures US positions subject to federal position limits. And finally, Andrew Ruddick, a member of the Chicago Mercantile Exchange, agreed to settle charges brought by the CME that on numerous occasions between March 1, 2012 and July 25, 2012, he personally traded based on non-public information regarding a customer's intended transactions. Specifically, during this time, claims CME, Mr. Ruddick traded personally prior to the beginning of the closing range in lean hog futures contracts based on his knowledge of a customer's market on closed orders. According to CME, Mr. Ruddick then closed his position during the closing range. Mr. Ruddick agreed to resolve CME's charges by disgorging profits of $114,000, paying a fine of $25,000, and not trading any CME Group product for 1 year. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal, and until next week, enjoy your later days, and ciao!